matter to come before the court this morning is State of Ohio versus Dennis McClelland. And as you both know, the appellant, well, both sides will have 15 minutes to present oral argument. Appellant will proceed first and may reserve up to 5 minutes for rebuttal. So we have read the briefs and we are prepared to go forward with you.
Thank you, Your Honor, and I would like to reserve 2 minutes of my time for rebuttal. And, Your Honors, if my voice should drop off, please remind me to try to bring it up. I'm not exactly healthy today.
Understood.
So, thank you. And again, good morning, and may it please the court. As you know, I'm Jacqueline McCord, and I represent the appellant in this matter, Mr. Dennis McClelland. Now, Mr. McClelland is currently serving 5 years in prison after pleading guilty to a drug offense. Prior to his sentencing, he moved the trial court to withdraw his plea, but that request was denied. He is now asking this court to remand his case back to the Common Pleas Court for 3 reasons. First of all, at the withdrawal of plea hearing, the trial court created a conflict between Mr. McClelland and his counsel that it deprived him of counsel. Secondly, the trial court ought to have freely and liberally granted Mr. McClelland's pre-sentence motion to withdraw his plea. And thirdly, Mr. McClelland did not enter that plea knowingly, voluntarily, and intelligently in the first place. Now, most importantly, though, which is the reason I presented that argument first, is that by creating a conflict between Mr. McClelland and his trial counsel, the trial court essentially deprived my client of counsel at a critical stage in the prosecution of this case. This issue hasn't really come squarely before this court before, but two other appellate courts have looked at this issue of what happens when a trial court requires an attorney to discuss details of the attorney's representation of the client at a withdrawal of plea hearing. And the 2nd District and the 6th District have both found that, at least in times when an attorney is required to testify as to the representation, that deprives the client of counsel, and that since this is a critical phase of the case, that merits a new withdrawal of plea hearing for the client with new counsel. And looking at this case, granted, my client's trial lawyer was not put on the stand and forced to take an oath and testify, but as attorneys, we are under a professional responsibility and obligation to be truthful to the court at all times. And so by telling my client's counsel, I want you to make a record as to your representation of Mr. McClelland, the court was doing the same thing as putting that lawyer on the stand. We are already under an oath to tell the court the truth, the whole truth, and nothing but the truth. There's really no effective difference between those two. And so by requiring Mr. McClelland's counsel to talk about the representation is creating a conflict.
And what specifically did the court inquire regarding?
Wanted to know about what the conversations were with Mr. McClelland, especially about the plea and the withdrawal of plea. And counsel revealed to the court that he had discussions with Mr. McClelland a few days before the plea hearing about withdrawing the plea. They tried to talk Mr. McClelland out of withdrawing the plea, talked about his meetings with my client's parents, transportation problems that my client had that prevented him from meeting with trial counsel, things of that nature. But the essence of it was, when a lawyer is asked to talk about the representation, what did you talk about with Mr. McClelland? What did he understand? In a situation like we have in this case, and like in the 2nd District and 6th District cases, when the client is making the motion to withdraw the plea, at least in part, on an allegation that trial counsel has been ineffective, which is what happened here, when a court requires a lawyer to talk about that, the court is putting the lawyer in an adverse position to the client. It's basically, the lawyer is put in the position of either trying to support the client's argument, and which would require the lawyer to say, yes, I was ineffective, or telling the court, I was not ineffective, and here's why, and my client's position is not meritorious.
Well, it seems to me that this is a very interesting legal issue. When I read the briefs, it occurred to me that your client was represented by legal counsel below, and yet he filed a motion to withdraw the plea pro se.
Correct.
So technically, the court wasn't required to consider that motion.
Technically, that's correct.
And the relevance to this analysis is that you're raising the argument that the client was put in a difficult position because ineffectiveness was raised. But we would rarely, if ever, see that situation if counsel were to be filing a motion to withdraw.
Well, if counsel were filing a motion to withdraw
On behalf of the client.
on behalf of the client, I can't see that the counsel would be raising his own ineffectiveness.
That's exactly my
Right.
point.
Right. So
So it is the fact that your client, even though he was represented by counsel, attempted to, be involved in sort of dual representation that sort of created this situation.
in a sense, but also I would remind the court that during the plea withdrawal hearing, my client also expressed a desire to dispense with counsel altogether and represent himself, because he did have such misgivings, rightly or wrongly, about his representation.
And that was in direct conflict with what he had indicated to the court at the time that the plea was given, correct?
That's correct. And as he explained to the trial court during the withdrawal of plea hearing, he was not aware of some of the things that he was complaining about until after he had made his plea. That, for instance, he was troubled by the fact that there were no motions that had been filed in his case whatsoever, and a fact of which he was not aware until after he had entered his plea.
How did that prejudice him in any way?
The lack of motions? That is not, we don't have enough in the record to say that there was any prejudice to him. However, when you have a conflict like this between lawyer and client, that presumes some prejudice. It's not necessarily that the lack of motions was itself prejudicial. It was, the trouble with this case arises because, and I'm going to say rightly or wrongly, because like I said, we don't have enough in the record to say that counsel was ineffective, okay? But my client believed counsel was ineffective and raised that argument to the trial court and said, I believe my counsel was ineffective. And so that created a conflict between lawyer and client. That essentially presumes prejudice under at least one of the arguments that I have. So that in itself could prejudice the client. How do you represent a client effectively once the client, for instance, says, I think you've been ineffective? I hope I've answered your question.
Well, could not just the question, what do you know about this issue about withdrawing the plea, create the conflict right then and there? Isn't that where you started? When the trial court examines counsel who is purportedly representing the defendant, who says he doesn't want that counsel, what do you know about this, him wanting to withdraw his plea? Or is that not how the testimony went back and forth at the withdrawal plea hearing?
That's not quite how it had gone. I think initially the attorney had said, in response to that type of question, well, you know, I've talked to my client. He wants to withdraw his plea. I'm asking the court to withdraw from representing this client. I'm asking the court to appoint new counsel to represent this client in a withdrawal of plea hearing. Okay? Then the trial court asked, please make a full record for me of what you've said with the client.
So I can make a determination on whether or not I'm going to allow you to withdraw, or I can make a determination on whether or not he's going to be allowed to withdraw his plea.
Whether he's going to be allowed to withdraw his plea.
The court then makes reference to an indication that the court believes he is doing this in some sort of schematic way so that his brother gets, who has already been sentenced that day, gets the sentence that was agreed to. And now it's time for his sentencing. But did he not file his pro se motion to withdraw his plea before his brother was sentenced?
Yes, the day before sentencing. And as I said, I contacted counsel 3 days prior to the sentencing hearing because he wanted counsel to make the motion to withdraw the plea.
Was it before the female got her sentence?
Yes. They were all sentenced together on the same day. So you had 3 days before the sentencing hearing where all three were going to be sentenced. You had my client call his lawyer and leave a message saying, I want to withdraw this plea, please, this is what I want to do. Then subsequent to that, again, prior to the actual court hearing, he talks with his lawyer, who tries to talk him out of withdrawing the plea. After that, he files his pro se motion the day prior to the sentencing hearing. At the sentencing hearing itself, you know, my client was defendant C in the list of the 3 defendants. Defendant A gets sentenced. There's discussion about my client's wish to withdraw his plea. Then I understand that his girlfriend was then sentenced. And then there's further discussion about the withdrawal of my client's plea.
So your position is that the court didn't get it right in its belief that that he was scheming to get the brother and the girlfriend the benefit of the joint plea, but escape more harsh sentence for himself.
That's exactly correct, Judge, because factually, he didn't see anybody else get sentenced before he made his request to withdraw his plea. He'd already made that request the day before in writing and had already decided that a few days before.
Hadn't they all been there in court? I mean, this doesn't happen in a vacuum. You know, that doesn't mean that he was not aware of what the discussions were about resolution for all of them, right?
Well, he had certainly been through the plea hearing that they were all at, and which I address in assignment number 3, regarding whether it was knowingly, voluntarily, or intelligently entered. You know, this was an assembly line hearing, okay?
I'm going to stop you there only because you are encroaching into your 2 minutes. And I thought that you might want to use that as your vote. But if you wish to finish that thought at this point, and you may.
I have lost that train of thought, Your Honor, so thank
Okay.
you. I will return to it on rebuttal.
Right.
Thank you very much.
May it please the court, Rachel Richardson on behalf of the state. Your Honors, this is a case in which Mr. McClelland was given exactly what he asked for in the beginning. This is a case that has gone on since at least 2014. There were numerous meetings of minds in this case. There are at least 3 co-defendants, which means numerous conversations took place. One of the parties is his brother, and the other party is his girlfriend.
What do you mean when you say he was given exactly what he asked for from the beginning?
The plea agreement that he was given is the exact plea agreement that he was sentenced to at the sentencing hearing. So there's no change, as he indicates, there was a change in the indictment. The only change in the indictment was to remove methamphetamine from one of the charges. There was no amendment of the indictment to indicate that he wouldn't have a felony or a felony of the first degree, as he indicates later when he wants to withdraw his plea. He gets the exact charges that were discussed. He gets the exact sentence that was discussed. And his co-defendants get the exact sentences to the exact charges that were discussed in the initial plea.
Was there a signed agreement? In other words, oftentimes when the state and defense counsel work out a plea deal, there will be a signed agreement that is actually signed by the defendant. Is that in the record before us?
I don't believe there is a signed agreement in this matter, Your Honor. So each of the defendants received the signed charges. It was a collective agreement. At the time they entered into the plea colloquy, none of the parties objected to any of the information. A proper Rule 11 plea colloquy was conducted. At no point did the defendant indicate that he had any questions or concerns. At the end of the plea hearing, one of the co-defendants requested to have sentencing begin. It was actually McClelland, one of the other, I believe, McClelland requested a continuance and the matter was continued because he wanted to get his matters in order. At sentencing, counsel states that client had contacted him 2 or 3 days before, stated he wanted to reconsider and maybe withdraw his plea. At that point, counsel states he feels obligated to make an oral motion for leave for McClelland to withdraw his guilty plea and say it was McClelland's intention to ask the court to appoint new counsel.
What's in the record about this allegation on behalf of the appellant that he only had 2 minutes to consider the plea deal?
There's nothing in the record, Your Honor, to support that allegation. And as far as the deal that was offered, none of the other parties indicated that they didn't have enough time. There's no concern about the length of time in sentencing for anyone else. Like I said, Your Honor, this is a 2014 case, and I would find it hard to believe that the state hadn't offered this deal or a similar deal over the course of many conversations. Generally, there is a deal offered early on in the case to try and expedite the process. So in a discussion that only 10 minutes occurs between the time of 2014 and 2015 would seem disingenuous and seems to be what the court believes as well in this case.
What of the appellant's argument that the court created a conflict of interest between counsel and Mr. McClelland during his motion to withdraw his plea hearing?
Your Honor, I don't believe there is any real conflict here when counsel is acting still in his in the client's best interest. In fact, he refers to the client. It's really a dual representation situation here. He receives the benefit of having his counsel and asks, is there anything that I'm missing? Is there anything that I'm not bringing to the table that you feel isn't being expressed? I mean, the court had the opportunity of reviewing the pro se motion, which they didn't have to. The court had the opportunity of hearing from all the parties involved. And it's not surprising, I think, in this case that the court didn't find that allegation disingenuous when, during the plea colloquy, none of this information had come up. And in fact, he asserts that there had been no promises made. There had been no problems with counsel. There had been no issues of time or consideration. He understood the charges that were before him. He understood what he was waiving. He understood that the charges that were there. I mean, now he's asserting, in fact, in one of his issues is that he's entirely innocent and his brother is innocent. Everyone is innocent. The court at this point is, I think, rightfully so, saying, why now is this an issue? Why now are you concerned and the court doesn't believe them? It's in the court's discretion whether or not to take that into consideration.
That might, I think, be well suited to the argument whether or not his counsel was ineffective, but it's my understanding at least that the question and answer relates to whether or not he will be allowed to withdraw his plea.
Once the court determines that there is no withdrawal of the plea and the withdrawal is not genuine, there's no actual basis for the withdrawal. I mean, the allegations were not deemed truthful. That's within the trial court's determination of assessing which information is truthful and which information is not. At no point is there an argument made that, does Mr. McClelland say, I want to represent myself, this is the information I feel should be made. He sits next to his counsel and lets his counsel say, I'm making this on his behalf. And in fact, at the beginning of the sentencing hearing, counsel states that he intends to represent him on the motion for withdrawal and on the motion. There is no argument that he shouldn't be representing him on those motions. No one ever says, I don't want him representing me at this point. Although there's an issue about finances, the counsel is still willing to represent the defendant, and the defendant actively allows him to represent him, never says, stop, I don't want to, which we know in this case the defendant can because he's already filed a motion saying he's unhappy, but he didn't even tell his attorney he files a motion.
What of the fact that counsel below asked the court to permit, to consider the motion to withdraw, but to appoint new counsel and allow him to withdraw? And the court just went on with the motion with questioning him.
Well, I believe counsel said that he felt obligated to make an oral motion and that he stated he believed McClelland's intention was to appoint new counsel. That's when the court then inquires, why do you think this? And that's why he responds. The trial court then kind of goes into their argument. So I don't think the scenario played out exactly as, I want new counsel, I want to withdraw. It's more of a passive scenario where everyone's just discussing on the record what the scenario is, what the facts are, to even see if that information is genuine enough to grant this motion for a new trial, to grant a motion for a withdrawal, or to grant a motion for a new counsel. The timing of this as well, two parties have already been sentenced, two parties have already been sent off onto their way. To withdraw this part for the third it would be difficult to revoke then the pleas that two parties have already entered into.
Well, did he not ask for his plea to be withdrawn prior to anyone being sentenced?
I believe there was some representation, counsel stated his client made contact with him to withdraw his plea, however the court proceeded.
And then it's my understanding when his counsel did not withdraw his plea, he sent in a pro se document regarding his desire, correct?
That's correct, Your Honor. And that pro se document is the first time that anyone even sees it is at the time of the sentencing hearing, in which the court sees and then provides to the prosecutor and defense counsel.
There was also some discussion of all three of the co-defendants moving to withdraw their pleas. I think that was maybe the attorney was saying it was his understanding after talking to the appellant that the other co-defendants also were going to join in the motion to withdraw, but that didn't happen.
That's correct, Your Honor. I believe that might be also part of the reason of why he sees the other two go through with it and realizes maybe his client didn't actually want this in part of a trial decision. There's no indication that counsel isn't actively speaking with the defendant. The only allegation is from the defendant saying now that he's not being heard. And really the record doesn't show, even the facts that were provided on the record, that the defendant wasn't provided with adequate counsel. There's no real reference here that he didn't understand the rights he was giving up, he didn't understand the charges before him, he didn't understand what he was waiving when he entered into the plea colloquy. All we have here now is someone saying that information that could be disingenuous, that you only had 10 minutes, that you felt railroaded into something, issues that don't necessarily invalidate the voluntary nature of the plea, that don't necessarily make an ineffective assistance of counsel as far as the plea is going. And then as far as the actual sentencing, he's granted the sentence that, if counsel was ineffective and should have been removed, there's nothing that counsel did at the point of sentencing that would have changed matters. Sentencing was exactly as it had been promised before. There's nothing that could be done that was ineffective at that point. So even if it wasn't effective at the point of the initial plea, there's no proof of that. And then at the point of the withdrawal, the only reason he wants to withdraw now, he's stating, is because he believes he's innocent. Information that is contrary to what he had previously told the court. Exact words, are you accepting guilt in this matter? Yes. How are you pleading? Guilty. So the court is being asked to consider this man's terms as either disingenuous at the time he enters his plea or disingenuous now after he's seen two parties be sentenced. Throughout the representation, McClelland's counsel also reminded the defendant and assisted him at several times saying, didn't you say something about having an issue with this? Didn't you say something about having an issue with that? I find it hard to believe that the defendant didn't benefit from having counsel in this case when his counsel was saying things that possibly were dissatisfied or not in his best favor. I understand that it would be difficult to ask counsel to not represent his own self as being poor counsel. However, the allegations made were that he didn't meet with them regularly. That's something that's a fact-based issue. It's not an opinion-based issue of services.
Well, in order to affirm, do we have to find that counsel was in fact effective?
No, Your Honor, there's case law in which there was ineffective assistance of counsel, but since the sentencing was as said, it's irrelevant whether or not he was effective at that time because his actions at that point were passive. Merely just standing there.
Essentially, he agreed to what the sentence would be at the plea hearing.
Exactly, so there was no active representation at that point from counsel. Is there anything further from the court? Thank you, Your Honors, and we would request to maintain the sentence. Thank you.
Thank you. Ms. Courtney, we have just under 2 minutes.
Thank you. I would like to clarify that what's not at issue in this appeal. The issue is not whether my client's trial counsel was effective at the withdrawal of plea hearing. And as far as whether a conflict existed between my client and his trial counsel during the withdrawal of plea hearing, the relevant question as far as conflict is not whether his trial counsel imparted any benefit to my client during that plea hearing, or that change of plea hearing. Instead, a conflict exists if the probity of a lawyer's conduct in a transaction is in serious question, because then the lawyer may have some difficulty or may even be unable to give a client detached advice in regard to the same matter. And that's paraphrasing Professional Conduct Rule 1.7, comment 20. So whether my client's trial counsel was effective or not, or tried in any way to assist Mr. McClelland during that withdrawal of plea hearing is not, neither of those are the relevant questions. The fact of the matter is that the probity of my client's trial counsel had been called into question, and asking him to make a record concerning his representation of the client created the conflict. And that's what stripped my client of all counsel, effective or not, at the withdrawal of plea hearing. Also, the question is not whether the court imposed an agreed upon sentence. That doesn't have any bearing as to whether it was proper or not to question his trial counsel about the representation or to deny the withdrawal of plea motion. And I'm not sure how much time I have left.
You timed it perfectly, you just reached your time.
Then I respectfully ask this court to reverse and remand this for further proceedings. Thank you so much.
Thank you both for your presentations. The court will take the matter under advisement, will issue a written opinion which will be sent to both sides, and do check the Supreme Court website in the interim.